Ready, start. Hence, the inference of complaint having been made and any file or file number K-115/1/2012 being transferred from the court of petitioner to another court, as indicated in the impugned adverse remark, does not appear to be borne out of record, full stop. On the above premise, the division bench allowed the writ petition, full stop. After having drawn a parallel in between the facts of the present case, it is apparent that while in the case of aforesaid petitioner, no inquiry was conducted to examine the seriousness of the allegations made against aforesaid petitioner, whereas in the present case, an inquiry was held but nothing adverse was found against the petitioner, full stop. We may further refer to the judgment of the Lucknow bench of this court in service bench number 6108 of 2017 within bracket Rajveer Singh versus Honorable Allahabad High Court Allahabad through Registrar General and others bracket close decided on 1/10/2018 full stop. The court, upon consideration of the material on record and upon evaluation of the submissions urged, ultimately, delineated its views, full stop. Reporting of any adverse remark should be based on some tangible material and not on any surmises, full stop. Discussion made above, lead us to the conclusion that in the facts and circumstances of the case, adverse remarks against the petitioner could not have been awarded, full stop. While saying so, we are conscious that it is impermissible for this court to substitute its own finding in respect of the character, role, entries of the petitioner in exercise of our jurisdiction under Article 226 of the Constitution of India. Full stop. However, what we have noticed in the preceding paragraphs lead us to observe that the adverse remarks could not have been awarded to the petitioner on the basis of the material relied upon by the district judge. Full stop. The material cannot be said to be germane, full stop, to complaints, which form the basis of the adverse remarks against the petitioner stood rejected by Honorable the Administrative Committee and the alleged critical comments made by the district judge while deciding the revision petition filed against the order of the petitioner is not a relevant material which could form the basis of such adverse remarks, full stop. Annual character role entries in the annual confidential report of an officer should be based on the overall assessment of his/her work and conduct, full stop. In this context, it is noticeable that service record of the petitioner is unblemished ever since he joined the service as a judicial officer, except the adverse remarks entered in the annual confidential report pertaining to the year 2011-12, which is under challenge in this petition, full stop. For the reasons given and discussion made above, we find that the writ petition deserves to be allowed, full stop. We find that the facts of the present case and that of aforementioned petitioner are in congruence inasmuch as, there is no such distinguishing feature on the basis of which, the ratio laid down in aforementioned judgment could be held to be inapplicable to the facts and circumstances of the present case, full stop. Accordingly, the order impugned herein is set aside, full stop.